I'll be very brief, my lord.
3991.
Of 23. My lord, I'll be very brief and to the point.
Take a second, just let us get it out. CMA.
What is CMA number, right, sir?
My lord, 3991. May it please your lordship. We've heard
Do we
various...
need to have it before us or we don't need to have it before
My
us?
lord, if I do, I'll sort of, to a very limited extent, I'll refer to that later. If I may just address, my lord, that we are trying to understand the various meanings hidden within the few articles of the Constitution. In order to do so, the basic rules of interpretation, which according to this honorable court have been, are to be utilized in reading and understanding these provisions. First, let us just identify that. How are we to read these articles? My lord, the Honorable Supreme Court in the Sui Southern Gas case, 2018 SCMR 802.
802.
802, my lord. The court summarized.
Have you given a paper poke or something with these?
My lord, ये तो judgments.
Judgments. अच्छा.
Judgments की मैंने
You've just
I'd
given
given
a
the
list.
list. I'd given the list in the morning.
Okay.
Yeah, you mentioned it in paragraph 3 of your CMA.
ये निकाल देना.
In the case of Sui Southern Gas.
My lord, because
You have reproduced.
I want to read the just
Pardon me.
one sentence from the judgment.
Relevant page?
My lord, relevant page is at 830.
830.
830. What the court did here was it looked at all the case law, it looked at all the treaties from A.K. Broi Saab's to Justice Fazl Karim's to Servai Saab's, and it summarized the rules on how we are to interpret Constitution. And my lord, those rules are summarized on page 830. A through I.
830.
I will not read all of those, but on the next page, 831, the Supreme Court cites with approval a judgment, and that is at paragraph 14B. Uska ek, I mean, that sentence really encapsulates how we are to read these provisions. My lord, paragraph 14B. It's a Indian Supreme Court case which has been cited, and it says, the cardinal rule of interpretation, however, is that words should be read in their ordinary, natural and grammatical meaning subject to a rider. First rule is cardinal, ordinary, natural, grammatical meaning, subject to this rider. My lord, I'm reading from 14B, paragraph 14B. Subject to a rider. That in construing words in a constitutional enactment, conferring legislative power, the most liberal construction should be put upon the words so that the same may have their effect in the widest amplitude.
Take.
This is the basis on which we are to interpret these provisions of the Constitution. My lord, with regard to entries,
Mr. Ibrahim, this principle is applicable in all eventualities?
my lord, that is what this judgment says. And I'm just setting out the basic rule that the Supreme Court has set out. And then, my lord, at page 838,
There is absolutely no departure from this?
No, obviously, my lord, we make departures when we are reading and in trying to interpret. But a basic rule is set out. First of all, you determine what are the rules of the game on how do we read these provisions. And one of the rules that it says...
You see the situation which has arisen out of the proceeding which have been going on, whether this en bloc interpretation is applicable?
In my view, yes.
This how come?
In my view, yes. And I'll come to that. My lord, on page 838, entries of the legislative lists on how they are to be read are also, the rules on that have been summarized. And if we see 838, the rule set out in paragraph 2, in construing the words in an entry conferring legislative power on a legislative authority, the most liberal construction should be put upon the words. 3, while interpreting an entry in the legislative list, it should be given widest possible meaning and should not be read in a narrow or restricted sense. 4, each general word in an entry should be considered to extend to all ancillary or subsidiary matters which can fairly and reasonably said to be comprehended in it. My lord, if we read these provisions, now coming to the matter at hand, my reading in relation to the practice and procedure part of this law, I'm not referring to the appeal part, the practice and procedure part. My lord, the legislative competence in my view arises from Article 142A, where the Parliament can make exclusive power to make laws in respect of matters in the legislative list, federal legislative list. From Article 142, I look at the federal legislative list and I look at entry 58. Entry 58, matters which under the Constitution are within the legislative competence of the Parliament or relate to the Federation. Matters which under the Constitution are within the legislative competence of Parliament.
You see, if you
What are the matters?
go by that argument, then there is no need for any other entry in the legislative list. Just this one article, this one entry would cover everything.
With, if I may answer your Lordship's question, that does this provide then complete free hand? No. It is only to the extent, the language is very clear, sir, and it's not all encompassing. It says matters which under the Constitution are within the legislative competence of Parliament. What is within the legislative competence of Parliament? Article 191, and this is where subject to law comes in, and the reading of that provision. So what I'm doing is,
What do you mean by, Mr. Zahid,
my lord,
entry number 55 is not applicable here?
no, entry number 55 is also.
58?
Because, and I'll come to that. Because entry number
but then
55
The legislation has been made in both entries.
in both, yes, yes, and I will come to that.
Mr. Zahid Ibraheem, what is then your argument in relation to the judgments which have been cited?
Yes.
That subject to the Constitution and subject to the law as mentioned in Article 191 is a restrictive provision. It is not a provision which confers jurisdiction or confers powers. It restricts. What's your response to that?
My lord,
Can you please do respond to the queries, but can you just complete your thought, because my pen has been left in the air. I don't know what you're going to say next. Suspense is killing me.
Your Lordship's observation.
Respond to them.
Because I will respond to it because I have, I will
Let's complete
refer to
your thought.
Justice Anwar Bhinder's case and try to express my view on this. for your Lordship's consideration. So what I was saying is that in 142, entry 58, entry 55, and then you look at Article 191, where subject to the Constitution and law, Supreme Court may make rules regulating the practice and procedure of the court. Now, the argument being made by those who are challenging this law are saying that once the Supreme Court has made rules, then the door closes. Then there is no subject to law. You cannot do this. My submission to this Honorable Court on that will be that this court, in Justice Anwar Bhinder's case, has said the opposite. In Justice Anwar Bhinder's case, where it was looking at Article 188 there, the power to review. What did Justice Anwar Bhinder's case hold? My Lord, this is PLD 2010, Supreme Court 483.
Which paragraph do you?
My Lord, there are two paragraphs in this, my Lord. First, I would like to refer to page 523, 522 and 523. My Lord, paragraph 25. After reproducing Article 188 of the Constitution, where Supreme Court is been given the power subject to provisions of any act and of any rules made by the Supreme Court to review any judgment pronounced or any order made by it. Paragraph 25 says, a bare perusal would reveal that it has been couched in a very simple and plain language, hardly necessitating any scholarly interpretation. It inter alia provides that the Supreme Court has power to review its judgment or order subject to the provisions of any act of Parliament and any rule made by the Supreme Court itself. The contention whether the Supreme Court rules are subservient to the Constitution have been discussed in a later part of this judgment. Now this, my Lord, the next sentence is critical. Critical. It says, it is to be noted that no act of Parliament whatsoever has been promulgated, and thus it can reasonably be inferred that legislator does not want to restrict or impose any condition on the powers conferred upon this court under Article 188 of the Constitution.
अगला भी जुमला पढ़े ना
जी जी
अगला जुमला भी पढ़े
In fact, the word subject to provisions of any act of Majlis Shura and any rules made by the Supreme Court are indicative of the fact that indirectly the powers so conferred have been enhanced, and there was absolutely no intention for curtailment of such powers conferred upon this court under Article 188 of the Constitution.
This is what it is being said, that because you see, if you read on in paras 36, 37, the discussion is that even the power of the court is to enhance the power. It's not to curtail it.
My Lord,
You can't just pick one sentence out of it.
but at least one sentence we have to read also.
you can't read one sentence when the context is provided by the immediately following sentence. How can we read a judgment?
I'm not seeking that.
आप आगे जाके पैरा 36 तो पढ़े ना 36, 35, 36,
सर मैं पैरा 36 भी पढ़ लूंगा. मेरा सिर्फ ये कहना है कि जब सुप्रीम कोर्ट ये कह रही है,
एक जुमले से तो बात
नहीं जरूर मैं
let me come back to
आप अपना आर्गुमेंट तो कंप्लीट कीजिए ना.
argument please complete करें.
entry 58.
आपका आर्गुमेंट है क्या? मैं नोट करूं फिर?
Let me come back to entry 58 first. आप कह रहे हैं कि matters under the constitution are which are within the legislative competence of Majlis Shura Parliament or relate to the Federation.
My Lord.
This should be given the broadest possible meaning.
Yes.
And you relate this to the rules, well-settled rules of interpretation that you have already read out.
Yes.
and you relate this back now to law,
Yes.
as my learned colleague has already said, that this begs the question whether that is an enabling power. But my question is slightly different.
My lord.
जो rules of interpretation जो आप जिनका जिक्र कर रहे हैं और जिन judgments का आप जिक्र कर रहे हैं, as far as I am aware, those are concerned where the grant of legislative competence was by the entry itself. Okay? The grant was, that is the context in which those judgments are given. Okay? Now, as you are aware, an exclusive legislative list, whether federation or even the provinces, 35 Act, 56 Act, we don't need to go into that. An exclusive legislative list, especially now in the context of 73 Constitution as it presently stands, has two effects. One is positive. The legislative entry confers a power, a legislative competence, but the other is negative. The negative is that it excludes the other legislatures from making any such law. So if you look at it and interpret it in the broadest possible terms, which is the correct way to interpret these entries, it has two effects. It describes constitutionally what is the scope of the legislative grant that is being conferred positively. Negatively, it excludes the other. I put it to you that if 58, which does not itself confer any legislative competence, the effect and purpose of this is not positive but really negative. To clarify, to put it in the absolute clearest possible terms, that whatever power, legislative power, is given not in these entries, no, in the Constitution itself. Article 151, article this, that, the number of judges of the Supreme Court, so many other examples can be given. That has, Article 58 is making clear, no intrusion by the provinces, none whatsoever. This is an exclusive grant to Parliament. So therefore, and I put it to you, that the way you are looking at it, it seems to me, with all due respect, and relying on those principles of interpretation, is perhaps not correct, because this is not a grant of legislative competence. It is merely shielding a grant made elsewhere, outside, other than on the legislative lists. It is shielding that from any possibility of encroachment by the provincial legislature. So that is its true purpose. What would you say to that?
जाहिद साहब, इससे पहले कि आप यकीनन इनके हमारे मोहतरम दोस्त का जवाब दें सवाल का, मगर मेरा फिर कलम हवा में रह जाता है। आपका अगर मैं एक दफ़ा लिख लूँ आपके पॉइंट क्या है, फिर ज़रा मुझे समझ आएगा, फिर बेहतर आप जवाब भी दे सकेंगे। ज़रा आप अपनी बात कंप्लीट कर लें, फिर जवाब ज़रूर दीजिएगा, नोट कर लीजिए।
So the point I was making, that yes, you read this entire judgment together.
Proposition बता दें।
Proposition is,
अपनी proposition दें, judgments, you know this is the full court. आप अपना व्यू हमें दें, आपका व्यू क्या है?
My lord, मेरा व्यू ये है कि जस्टिस अनवर भिंडर्स केस में सुप्रीम कोर्ट ने ये फैसला किया है 188 को इंटरप्रेट करते हुए कि क्योंकि पार्लियामेंट, जहाँ सब्जेक्ट टू लॉ लिखा है, क्योंकि पार्लियामेंट ने कानून नहीं बनाया है, उसका ये मतलब नहीं है कि रूल्स विल कंटिन्यू टू होल्ड द फील्ड एंड देयर कैन नॉट बी एवर एनी लॉ. My submission is, my reading of Justice Anwar Binder's case is that this case itself acknowledges that Parliament has not made but can make law. That is my.
Are you saying that the judgment is interpreting legislative competence through subject to law and constitution? So where in the judgment exactly does it say subject to should be read as enabling, granting legislative competence?
No, my ladyship, all I am saying is, because justice in this case, again, the issue was that there was no law. There was made by Parliament in relation to, for instance, abhi jo review of judgments ka law aaya tha, and which has been struck down. All I am saying is that the court, when looking at Article 188 at that time, all it was saying is, listen, there could have been a law, there isn't, but we are not trying to say that there can never be.
But please look at the wording of 188. It's very different from 191.
Exactly.
It doesn't say subject to. एक second ना जी, आप कह रहे हैं subject to the constitution and the law को हम enabling पढ़ें as a source of legislative competence. And you want us to rely on the Anwar Bhinder case in pursuance of this point, which is reading an article which does not say subject to. It is an article which actually says the Supreme Court shall have power subject to the provisions of any act of Majlis-e-Shura. It is saying that that act of Majlis-e-Shura and of any rules made by the Supreme Court. So there is a difference. This is a question that we've been working our way around, that what's the difference between an act of Majlis-e-Shura and the law. There is a difference. When you read subject to the law as an enabling provision, you bring in that executive action like an ordinance. You bring in that many other forms. So you're saying that the Supreme Court rule-making power becomes subservient to all those sources of law that exist, that the Constitution recognizes as being part of the law. So hence, can you explain through this judgment how that helps your point?
My Lord, my ladyship, first of all, when we say law, it certainly includes an act of parliament. And I acknowledge that 188 is different from 191. In 188, in fact, the Supreme Court has been given the power of review. In 191, there is no power. There is only acknowledgement that Supreme Court may make rules.
There is a power
The language
given
is
to
different.
the Supreme Court. It's
My Lord, the language is different.
Power conferring article which empowers the Supreme Court to make rules, and then a judgment of this court again. It's I think in the NRO judgment which says rules framed under constitutional powers, i.e. the 1980 Supreme Court rules, stand on a higher pedestal compared to ordinary legislation. What does that mean?
If I may, with utmost respect, I know your lordship in the Ghulam Mohiuddin case recently rendered judgment where the Supreme Court review law was held to be illegal. Your lordship has expressed exactly that point.
No, this is not our expression. That is a reliance on an earlier judgment of this court which says this.
My Lord, all I was trying to point out that the language of 188 and 191 in granting powers to the Supreme Court uses very different languages.
But you see, even this judgment that you're relying on, this also says that the Supreme Court rules are on a higher pedestal and promulgated on the basis of a mandate given by the Constitution.
Thank you.
Exactly यही कह रहा है.
Thank you for pointing out. Let me again, in relation to this judgment also, now clarify what this judgment has actually said and what it is purportedly argued that it has said.
No, argument apart, as Ladyship also pointed out, and as has been mentioned earlier, the judgment that you rely upon in itself lays down this, the ratio of the judgment is that the rule-making power, when exercised, when the rules are framed, then such rules stand on a higher pedestal for the reason that those rules have been framed in exercise of powers granted by the Constitution itself. And the powers granted by the Constitution under 191 are the powers granted by the Constitution to the Supreme Court and not to any other organ of the state.
My Lord, if we can just see page 536 of this judgment on this point alone.
Before you come to 536, just one quick question. This sentence that you have read out to us from page 523,
Yes.
which you regard as critical, is it your understanding that this is part of the ratio of the judgment?
Yes.
This is para 25 head note K जो है ना आपका इसमें पढ़े नहीं है. In fact, the word subject to the provisions of any act उसको define किया इन्होंने.
जी सर मैं
बिल्डर वाले केस में.
हाँ मैं एक सेकंड
जाहिद साहब आप चले आर्ग्यूमेंट तो अपना करें ना.
जी जी जी. So I was trying to yes, page 536 of the judgment, my lord, of the same judgment.
Mr. Zahid,
जी पढ़िए.
para 36 is more relevant.
सर मैं उसी पे आऊँगा सर, अगर एक सेकंड के लिए. ये हायर पेडेस्टल वाली जो बात है,
जी
530 पेज 536 पे फर्स्ट पैराग्राफ. The Supreme Court rules are on a higher pedestal and promulgated on the basis of mandate given by the Constitution itself and not by a government, object whereof was to enhance the power of review as conferred upon the Supreme Court under Article 188 of the Constitution. One more time, just the first part. Supreme Court rules are on a higher pedestal. Higher pedestal than what? ये इसकी जो प्रीसीडिंग पैराग्राफ प्रीसीडिंग पेज है, अगर हम उस पे जाते हैं,
इसलिए कहा है कि रिव्यू में पावर बढ़ाए हुए हैं रूल्स ने.
सर इसमें ये
I'm trying to understand, Mr. Zahid, Ibraheem. Please, can you complete your thoughts? Take the questions, note them. You keep responding to every query. I don't know what you're going to say next.
Okay, my lord. All I was the point.
Again, you were on 236 AA.
The
Yes.
point that I'm making is that in this judgment, when the Supreme Court says that the rules are on a higher pedestal because they are made under constitutional sanction, what are they saying? Higher pedestal than what? Higher pedestal than law or something else? They are saying higher pedestal than rules made on the basis of another statute.
No.
And if I may just complete, I will complete.
If you would also read the NRO judgment, this point has further been elaborated by this court by saying once these rules are made, any subsequent legislation we may not follow. And we need not follow.
मेरी सिर्फ आपसे ये गुजारिश है कि यहाँ पे जो कंक्लूजन हुआ है फुल कोर्ट का in relation to the Supreme Court rules being on a higher pedestal, that is not on a higher pedestal as compared to any law. And the reason why I say this is evident because this discussion started from page 500.
Can you just complete your thoughts?
534. Page 534 at the bottom of page 534.
Para 37.
Para 37, my lord. Exactly.
Mr. Zahid, para 36 is very important.
चलिए जाहिद साहब आप प्लीज आर्ग्यू करिए as you want to.
Para 37 का ये I'm just
जाहिद साहब अगर मैं आपसे सवाल ऐसा पूछूं जिससे मैंने फैसले ही कर रहा हूं तो आप कहें फिर सवाल ही नहीं बनता है. आप अपना आर्ग्यूमेंट कर लें कंप्लीट, फिर हम आपसे सवाल पूछ लें.
I mean, I honestly feel that I'm trying to answer questions.
आप पहले आर्ग्यूमेंट अपना कंप्लीट कर लें ना.
They help in this debate.
जी.
So I was just wanting to read para 37 from the bottom. मतलब जो in Roman font है उससे पहले वाला एक sentence. A line of distinction. In this regard, reference may be made to the case of Federation of Pakistan, Saeed Ahmed, PLD 1974. A line of distinction is to be drawn between statutory rules made by the executive pursuant to an act or an ordinance and statutory rules made by the Supreme Court pursuant to the mandate of Constitution as conferred upon it by Article 188 of the Constitution. ये जो sentence है, my lord,
A line of distinction.
a line of distinction is to be drawn between statutory rules made by the executive pursuant to an act or an ordinance and statutory rules made by the Supreme Court pursuant to the mandate of the Constitution as conferred upon it under Article 188 of the Constitution. That is what is being.
But if,
Ajay, can you now go back to 536 AA?
if this line of distinction is drawn, Mr. Zahid Ibraheem, if this line of distinction is drawn,
Yes.
that which means that the rules made under 188 are of a different category altogether, then there's no need to say that those rules are at a higher pedestal. Then those rules and rules made which are normally called subordinate legislation fall into two different categories. It seems to me that the passage, that those words that you have just read out from page 536 on a higher pedestal is not vis-a-vis a category that the Supreme Court in the words that you have just read out,
My lord,
say fall into a totally separate and distinct category. And if this is correct, then the higher pedestal can surely be only vis-a-vis law and not subordinate legislation or rule-making power, which is of a totally different nature. Would that not be a proper reading of the judgment as a whole?
perhaps like the first sentence of paragraph 37, in fact, perhaps answers what your lordship is saying. Supreme Court itself says, in view of the above discussed principles of interpretation, it seems immaterial to discuss whether the Supreme Court rules are subservient to Article 188 of the Constitution. They say that is an immaterial argument. Where it draws a comparison and says that they are on a higher pedestal, that is only in relation to rules made under some other statute. That is the point.
आगे बढ़ें.
My lord,
And if we go back to 536 AA,
Mr.
now if
Zahid,
we are to read this line disjunctively, object whereof was to enhance the power of review as conferred upon Supreme Court under Article 188 of the Constitution, then if we are going to read it like the petitioners want us to read it, that would mean that the Supreme Court is not bound by Article 188 either, because it's giving it more power than the Constitution itself. Surely that cannot be the case. So it has to be read in context to the line that you've read. I don't know.
I understand that, we are all pressed for time. I don't want to sort of.
हम पढ़ लेंगे पूरा judgment.
My lord, the next point I want to make is in relation to the appeal.
But before you go to appeal, what do you say about entry 58 on which you rely upon? That entry 58 is, since it is not conferring legislative competence, the rules that you rely upon, rules of interpretation, the purpose of entry 58 is the negative aspect of those rules, to make sure that a competence given elsewhere other than the lists, that is totally outside the scope and power of provincial legislature. That's all that the purpose of 58 is. It does not confer legislative competence, and therefore the principles that you rely upon really don't apply. What would you say to that?
My lord, my response to that would be that.
ये Zahid साहब बहुत अच्छा सवाल है. Shall we take the break now? And you have received a number of queries. Just mull them over. But then you just be precise in your answers, because we will hear you. Don't worry. So we can take a slightly longish, make it this lunch break as opposed to 1:30 and the prayer break or whatever we want to make it. Just make these questions are very valuable for food for thought, and then mull them over and respond to us.
Lord, I promise.
We will just come back in half an hour. Is that all right?
I promise to continue, but I can't promise to be able to have all the answers to the questions posed.
ठीक है.
You've seen what's been happening these last few days.
Yes.
You should be ready for that.
I've tried, my lord.
आप लोग भी जरा रेपिटेशन ना कीजिएगा, कोशिश कीजिएगा, नए बातें कीजिएगा जो इन्होंने नहीं की हैं. चलें, ऐसा होगा.